Good morning. Good morning. Welcome to this year's Bench Bar Breakfast. Judges, we especially want to welcome you to the State Bar of Texas annual meeting. It has been my great privilege and honor to co-chair this annual meeting. Our committee has worked so hard to put this program together and the other programs that you've been attending, and we hope that you are enjoying them as much as we are. Thank you again for being here this morning, bright and early. We hope that you will continue to enjoy our program today. We have another full day of CLE ahead, so please take advantage of all of that CLE opportunity sponsored by our State Bar sections. We are here this morning to honor our Texas judges. So right now, I would like to turn the program over to Chief Justice Rebecca Martinez, Chair of the Judicial Section of the State Bar of Texas.
Good morning, and thank you, Courtney. On behalf of the judges and justices, I want to thank the State Bar of Texas for hosting this wonderful event and allowing the justices and judges to attend the full day of CLE at no cost. I have enjoyed my time as a judicial section liaison to the State Bar Board of Directors and have witnessed firsthand the good work that is done on behalf of the lawyers and public in Texas. As a former board member of TYLA many moons ago and board member, I am thoroughly enjoying seeing the advancements that our president and her predecessors have taken on. Now it's my privilege to turn the program over to State Bar President Cindy Tisdale.
Thank you, Chief Justice Martinez. And on behalf of the State Bar of Texas and the Board of Directors, thank you so much, Chief Justice, for ably representing the judicial section on the board this year. At this time, I would like to turn the program over to Justice Busby to the podium for a brief presentation. Justice Busby.
Thank you so much, Cindy, and good morning, everyone. Thank you. It's my honor to come before you for a special presentation this morning to our Chief Justice, Nathan Lincoln Hecht, who is the 27th Chief Justice of the Supreme Court of Texas, the longest-serving member of the court in Texas history and the senior Texas appellate judge in active service. He's widely respected both in Texas and nationally for his distinguished service, his commitment to the rule of law, and his efforts to ensure that Texans living in poverty and others with modest means have access to basic civil legal services. As the Chief puts it, justice for only those who can't afford it is neither justice for all nor justice at all. For his many years of faithful service and effective leadership, and his unswerving belief that everyone should have access to the justice system, independent of their social status, the Texas Access to Justice Commission is presenting him with what will henceforth be known as the Chief Justice Nathan L. Hecht Access to Justice Leadership Award. This award will be conferred only when a worthy individual is nominated. In deciding who merits this honor, the Commission will use these criteria. The Chief Justice Nathan L. Hecht Leadership Award is given to honor an individual who has demonstrated the following: through personal characteristics of perseverance, fortitude, compassion, and courage, the ability to convince others of the necessity of an American justice system that affords meaningful access to justice for all, from the wealthy to the poorest. Through effective and tireless efforts, the ability to draw others to support meaningful access to justice for all and to champion for themselves the cause of access to justice as a righteous cause. And through skillful and reasoned advocacy, the ability to increase resources dedicated to ensuring access to the justice system and progress in the removal of barriers to all Americans achieving access to justice when needed. As someone whom the Chief has personally inspired to support greater access to justice, I can think of no more fitting description of my Chief, my colleague, and my friend. It's an immense privilege for me to be on this stage presenting the award, your award, to you this morning, Chief Justice Hecht. Each time this award is presented, it will serve as a testament to all you've accomplished as a servant leader and a call to action to continue advancing this vision that's so central to your legacy. Texas and her citizens are forever indebted to the work of your days. Please come forward.
Well, thank you, Justice Busby, and thanks to the Access to Justice Commission. I can tell you that over the years, the work of trying to improve access to justice for the poor has been a labor of love, and we, looking over the country, the need is so great, and it's great here too, but we've made lots of progress in Texas, and it's just been an honor for me to be a part of it. So thanks very much.
Chief Justice Hecht, thank you again so much for all that you do for the legal profession and for your support of this week's events. Now it is my pleasure to introduce this morning's keynote speaker, Professor David Granardo. David Granardo is a professor of law and associate director of the Holleran Center for Ethical Leadership in the Professions. He joined St. Thomas Law in 2022. He was previously a professor at St. Mary's University School of Law here in Texas, where he taught professional responsibility, contracts, sports law, business associations, civil procedure, oh, that just gave me nightmares, civil procedure, and international sports law. Professor Granardo earned the prestigious Warren E. Burger Prize awarded by the American Inns of Court for his article titled Debunking the Major Myths Surrounding Mandatory Civility for Lawyers, plus 5 Mandatory Civility Rules That Will Work. He received the National Award and made his acceptance speech at the Supreme Court of the United States on October the 28th, 2023. Please join me in welcoming Professor Granardo to the stage.
Thank you so much for that introduction. I'm going to start with a sports story. I played football at Rice, if you call that football, and I teach sports law. So that's where we'll start. There's a series on Netflix called The Quarterback, and Patrick Mahomes was featured on that series, as well as Marcus Mariota and Kirk Cousins. So Kirk Cousins was the quarterback in Minnesota for several years. He just left. But during the series, they talked about how during the season, every week, there's one day that he took off a week. He wouldn't think about football, would spend time with his family, just a day to get away from football. Unfortunately, that day was Sunday. So I would tell that joke in class because in Minnesota, it's about half Packers fans and half Vikings fans. So it's good to insult half the class when you're starting off. I tell that story because I'm thinking back to the first time that I talked about mandatory civility on a national stage. That was in 2013 in San Antonio at the ABA's conference on professional responsibility. And I remember that morning before I was going to present, I ran into the dean at the University of Wisconsin, Margaret Raymond, who's now the dean emeritus, and she said, "Hey, what are you presenting on?" I said, "Well, I'm presenting on mandatory civility." She goes, "Whoa, that's going to be rough." And I thought, I'm preaching the choir here. This is going to be great. I get in there. It was literally the most uncivil panel I've ever been a part of. We were getting yelled at. So we had a judge who may be in this room right now, and they were literally yelling at him, saying, if you guys would be more civil, and if you would take care of your courts, then we'd have more civility. And then I had somebody who was the chief disciplinary counsel from Arizona, and they were yelling at her. And they said, if you would stop giving favoritism to big law and trying to just punish the solo and small firms, we'd have more civility. We didn't get hit with any tomatoes because there wasn't a meal being served, but I had no idea that we'd receive that much hostility when we were talking about mandatory civility. So we're going to talk about it today, though, and I hope we don't have any tomatoes out there. So let's get into it. Objectives, because I practice for almost a decade in Los Angeles and in Houston in big law. So Jones Day, DLA Piper, and King and Spalding. And then now I've been teaching. This will be my 14th year of teaching. So as a teacher, we got to go through some objectives. Define civility, understand what it is, debunk the major myths surrounding it, and then, of course, discuss the proposed civility rules. This is the definition I use. Very simple, straightforward, treating others with courtesy, dignity, and respect, as well as demonstrating cooperation, honesty, and restraint. So this obviously was one of the most famous quotes about civility, and it really focuses on three aspects. One, enhancing the pleasure that lawyers find in practice, and of course, increasing the effectiveness of our system of justice. We'll talk about this a little bit more in a second, and improving the public's perception of lawyers. We'll talk about that as well. In response to the Rambo litigation tactics in the 80s and the 90s, there were a number of responses. One of the responses was creating these civility codes. And Professor Donald Campbell looked at what he said, over 140 civility codes created by local and state bar associations. And these were the 10 common core concepts. So we have a lot of judges and lawyers in here. I'm sure you can read probably better than me. But these were the general things that he drew out of them. Interesting, I like number 9, act as a role model to the client and the public and as a mentor to young lawyers. So I know that a lot of judges do that and do that very well, and that's important for all lawyers and judges to do that. Now here's just a few examples of some of these rules found in civility codes. Very general, owing a duty of courtesy. And the third one is interesting, shows up a lot. Sometimes our clients want us to be the bad person, to be uncivil. We have to tell them, no, that isn't right. Okay, so that was one of the responses to the incivility that was being seen throughout the legal profession. Another major response was adding civility into the oaths of lawyers when they started. Texas did that as well. And here's the language regarding it: and I will conduct myself with integrity and civility in dealing and communicating with the court and all parties, so help me God. What was interesting, looking at the legislative history for when this was added to the civility oath in Texas, one of the contentions was this better not be used as a basis for sanctions. So that was part of the understanding that it would not be mandatory civility, and that was one of the reasons it was passed at the time. 23 other states have also added civility into their oaths, and this was an effort by SBOT, the American Board of Trial Advocates, which is a wonderful organization filled with plaintiffs and defense attorneys as well. And it's one of the major movements that they have is the Civility Matters Project, which some of you may have taught in law schools and around the state. But here I'm highlighting South Carolina's oath. And the reason I'm doing it is because South Carolina is one of the 4 states that mandates civility. And they do it based solely on this oath. So to opposing parties and their counsel, I pledge fairness, integrity, and civility, not only in court, but also in all written and oral communications. So when South Carolina made this a part of their oath and said, we are going to mandate civility, they had every single lawyer who wanted to keep their license in South Carolina retake the oath, so that now they had notice of what type of behavior in civility would subject them to sanctions. So let's go through the costs. cost of incivility, losing a case. So there's a professor who said, well, if it's a really close case on the facts and the law, sometimes the decision maker, they'll choose the lawyer that's more professional. Okay, that may be the case, but certainly when someone is uncivil and because of the incivility, the lawyer and the firm get disqualified from the case, they certainly lose the client in that particular case. There was a case in Florida, and whenever I taught professional responsibility at St. Mary's, whenever I said there's a case in Florida, the students' ears would perk up. There's a case in Florida where a lawyer said, we are only going to have the depositions. The other side wanted to take depositions. The lawyer said, we're only going to have these depositions at the noisiest and loudest Dunkin' Donuts in town. And he wouldn't budge. And he said, nope, that's where we're having them. So then finally the other side capitulated. So they had the depositions at the loudest and busiest Dunkin' Donuts in town. When they arrived for those depositions, the attorney who demanded that they be held there, he showed up in T-shirts and shorts, and he was playing Angry Birds and drawing male genitalia throughout the entire depositions. So his defense was zealous advocacy. That's why he was acting like that. It was all zealous advocacy. The lawyer was disqualified from the case, and the firm was disqualified from representing the client in that case. That's a real consequence of incivility. Of course, also it increases costs for clients and it wastes judicial resources. So if I'm going to fight about everything in terms of discovery, and now I'm going to fight it. No, I'm not going to answer those interrogatories. I'm not going to produce those documents. Now the other side has to write a meet and confer letter. I have to respond to that meet and confer letter. The client's paying money for me to respond to that. We're going to have a hearing. There's going to be motion practice. There's going to be a hearing. The client has to pay for all of that. If there's a motion, the other side wants to continue a trial, and I have a story about that a little bit later. Somebody wants to continue a trial or a summary judgment hearing, whatever the case may be, and I want to oppose it. Okay, well, maybe the other person they have a spouse that's sick, a child that's sick, or an issue with the client, and I'm opposing it, and the judge may be upset that I'm even opposing such a motion. Well, that increases the cost again to the clients to show up to the hearing. And now, I'm preaching to the choir, literally, now the courts are flooded with motions to compel, with motions to continue, instead of hearing summary judgment motions, substantive motions, a trial, whatever the case may be. So it wastes judicial resources as well. And it increases stress for attorneys. So if the judges who practiced for a while, or maybe even not that long, can probably think of one or two names if they showed up on your phone that your blood would start to boil. So when I practiced in California, I had a pro bono family law case, and every time I saw this opposing counsel, every single time, he would say, I'm going to get you sanctioned. I'm going to get you sanctioned by the court we're in front of. I'm going to get you sanctioned by the State Bar of California. And finally I said, do you say this to everybody? And he says, yeah, I do. And I actually like you, David. So that was his tactic. And it increases the stress for attorneys when you're dealing with someone who is uncivil, obstreperous, rude, for whatever reason. The attorney can suffer professional harm. So I met with a well-known lawyer in San Antonio on one of the articles that I wrote, and he talked about how in San Antonio, if someone is uncivil, that they'll have attorneys talk to that newer attorney and say, look, that's not how we operate here. And after a while, that lawyer will be ostracized from the legal community, and we know the legal community is small. So an attorney can also suffer professional harm, certainly perpetuating negative perceptions and stereotypes about lawyers and the legal system. A lot of times folks believe what they see on TV, what they see in the movies. My older son, Solomon, he's 15. I have a younger son, Moses, 13. If we have another son, we'll just name him Lord or God and cut right to the chase. That's a whole other story. But he's been watching the show Suits, and now he wants to become a lawyer after watching the show Suits. There's a lot of unethical behavior. I got through about half of a show and realized that's not really how the law is practiced. But that's how a lot of the public believes that the law is practiced. And whoever's the loudest, who's ever the biggest jerk, who's the most obnoxious, that's the lawyer that wins. And certainly incivility, it perpetuates that stereotype. So what is mandatory civility? Let's be very clear about this. It means that lawyers may be sanctioned for uncivil conduct. May be sanctioned. It doesn't mean that they will be sanctioned, but it means that they may be sanctioned. That's a critical. We're going to talk about that in a second. So 4 states require civility from their lawyers. Florida is one of them. Florida, South Carolina, Michigan, Arizona. California is on the precipice of also mandating civility for their lawyers. The state bar, the Board of Trustees for the State Bar of California have approved changes that will add a rule of civility to the rules of professional conduct, add an hour of CLE, and will also require the lawyers to retake their oath. So that is now in front of the Supreme Court of California, and that is the last stage in terms of approval for mandating civility in California. So they may become the 5th state. So here are the advantages. Accountability. There have been, and having researched civility and incivility for over 10 years, I can tell you that there have been so many calls for civility. There have been calls to return to civility. There have been calls to return to civility. And at some point, there has to be some accountability. At some point, asking someone, can you please act professionally? Can you please treat others with dignity and respect? And at some point, that simply does not work. The carrot and the stick, at some point, you need the stick. And there are some people who sometimes get into the legal profession, even in law school. I've had law students who believe, no, I have to fight everything. I have to be rude. I have to be a jerk to be an effective lawyer. You don't. And some folks believe that even when they practice law. So at some point, if we want to improve the profession for all the reasons we talked about, there has to be some accountability. This is probably the ability to catch health and wellness issues, one of the primary reasons that when talking to disciplinary counsel in these states that have mandatory civility, that's why they love this. Because you're going to see that and if you read the article, you'll be the only person that read that besides my mom and my grandma. I'm kidding. My mom doesn't read any of my stuff. So, but what they'll tell you, and you'll see in there, is that a lot of times it's not even any type of public reprimand or any type of sanction that happens with offenses, with violations of civility. A lot of times it's maybe a diversion program. But even if it's not, if somebody's yelling and screaming at somebody at a deposition and opposing counsel calls the state bar, and it allows these disciplinary counsel to give that lawyer a call and say, what's going on? What's happening? And what they'll tell you, the disciplinary counsel, they'll say a lot of times, they'll find out that person just lost their paralegal. They left. That person is going through some emotional, personal issues. That person has there's some substance misuse going on. Maybe some anxiety, maybe some depression. It allows the state bar to step in and say, all right, we're going to send you to some lawyers for concern for lawyers meetings or TLAP. I saw Chris Ritter, a good friend here earlier today, and all the great work that, I know he's not with TLAP anymore, but he's with the state bar. But all the great work that the lawyer assistance programs do, they're able to connect those folks in those situations. And that has been something, if you talk to the disciplinary counsel, has been critical and crucial. You can catch now those issues when somebody is acting. I'm going to send you to a law office management or an anger management program. So that is, and we talk about it, we want it, and with law students now, we know that health and wellness is so critical for all of us. This is a great reason to adopt mandatory civility. Of course, it covers more lawyers. One of these rules specifically deals with also litigation, but also transactional lawyers. A lot of times, some of the rules that are out there, which are not perfect in terms of addressing incivility issues, a lot of times they're focused on litigation. Well, mandatory civility rules also cover other issues, other lawyers as well, transactional attorneys and others. Preserves judicial resources. If it's now a state bar issue, Now the judge can refer it to the state bar. So certainly if a judge sees something in their presence, they can say, all right, that's improper. Here's what we're going to do. But a lot of times incivility in a case happens outside of the courtroom, and judges don't want to play kindergarten teacher and hall monitor and, all right, let's go through this, who said what. So now if there's an issue outside of the courtroom, or certainly in a transactional matter, it can be referred to the state bar to handle. Certainly it reduces the cost to the clients. We're not arguing about these things. We're, again, and we're going to talk more specifically, but if there's a continuance that I talk to my client about and they're okay with it, and it's not prejudicing my client, then I should give that continuance, or at least not oppose it. It decreases stress on attorneys, allows attorneys to focus on the merits of the cases. All right. Also, of course, improves the perceptions about lawyers in the legal system, that we are being held to a higher standard. We should be exemplars of civility in society. And we know that there's studies out there, there's studies that are in the article that talk about the decline of civility in society, in the legal profession, and a lot of this talk, we'll talk about it later in the end, but it would be fantastic if the leaders here in this room said, look, I think Texas should have mandatory civility. So hopefully there are some folks in here, I know there are probably some saying, this is not going to happen, here are the ways it won't happen. I hope there are some folks in here saying, yeah, I think this would help, I know it would help, and here's how we can make it happen. And we're going to be, there's nothing that brings our country closer together than a presidential election. So we are headed here for a time of increased incivility, and a state like Texas, we'll talk about it, that has great lawyers that fight for their clients while maintaining civility would be the standard. It would be the standard. So here's some myths. Let's go through some myths. All right, one act of incivility. I'm a jerk one day, that's it. I'm going to be sanctioned. My career is going to be over. It's going to be terrible. Nope, that's not the case. You look at published opinions, case law, and common sense do not bear that myth out. Okay, so one case in Michigan, this is what they said in the opinion: one isolated incident of profane language did not constitute professional misconduct. So in that case, the lawyer was calling the other lawyer a lying son of a gun, I'll use the other word, and a shyster. And this is what the opinion said: litigation is by its nature adversarial. Oftentimes, attorneys involve themselves in heated, confrontational, and hostile exchanges. Words are often exchanged in the heat of battle, but when the emotions calm down, all is forgotten, and it's back to business. The practice of law involves cases where people's lives are at stake, where companies are at stake, where it's been the worst day or worst experience of someone's life. Disciplinary counsel, judges, or disciplinary panels that hear these cases, they understand that. They understand that. And in this case, literally, okay, you're not going to get sanctioned. They didn't even say this was sanctionable. In some states, in Arizona, it's repeated or substantial violations. So in another case, respondent attorney allegedly called opposing counsel a bleeping a-hole. That's actually my nickname at my house. Multiple times, I wish I was kidding, multiple times, and challenged opposing counsel to a fight. The disciplinary board viewed this as a situation where it was frustration, it was jest, and actually the respondent attorney walked away when opposing counsel said, all right, you want to fight? Let's fight, because he was saying it in jest. And they looked at it, the disciplinary board looked at it and said, look, it was a heated, contentious hearing, and opposing counsel had allegedly showed up an hour and a half late to that hearing. We understand that the practice of law is difficult. There's passion, there's emotions. And this was, yes, it was during this one period, but it was multiple times calling these names. And the court said, no, this doesn't even rise. This doesn't even rise to the level of a violation of incivility. This was in Michigan. So incivility as the only alleged offense is rare. A lot of times when people bring in the states where they have mandatory civility some type of incivility charge or complaint, it's with a number of other different complaints, maybe about diligence, maybe about communication, So it's very rare that they have this. A lot of times, if there even are sanctions, it's going to be a private or public reprimand. There is some suspensions out there for egregious behavior. My law students, I have one of my former research assistants, Callie Franks here. They typically enjoyed researching incivility. The suspensions were from the slaps. A lot of times, there's a lot of slapping happening at depositions where a lawyer slapping another. I don't know what those. At least we don't have that on Zoom, right? I hope not. There's probably a new thing in technology where you could put the thumb up, or maybe there's a slap you can do. I don't know. So anyway, but disbarment was found only twice in the cases, and that's where it was prolonged, egregious types of acts of incivility, and the lawyers were repeat offenders, and they thought they had done nothing wrong. I'm not going to tell you what state that was in, Florida. But a lot of times, talking to the disciplinary counsel, incivility cases, they're either just dismissed or they're resolved without any sanctions. So in myth number 2, holy schmoly, where the complaints about if you make incivility something that you can sanction, they're going to increase the civility complaints. Are going to increase dramatically, and we're going to need more staff. It's going to be all hands on deck. Not the case. So the two counsel that I spoke to, Michigan and Arizona, said they did not need to add more staff to the state bar to handle complaints when incivility was added as a rule. What's interesting is that in Arizona, the chief disciplinary counsel did say that they had a number of unprofessional conduct charges once they added civility. But again, they didn't have to add any more staff. In Michigan, they said, we actually have very few. And there's a very few cases where there's actually some type of order that goes along with it. And most of the time, it's a private reprimand or just an admonishment. Please stop that when there is some type of incivility complaint. Myth number 3, civility rules inhibit zealous advocacy. And I want to address this because there was a huge movement about zealous advocacy, the word zeal, a movement to get rid of the word zeal out of the preamble, the rules of professional conduct, or its derivative, zealous. And I don't agree with that. I understand why people did it, but I don't agree with that. When I teach law students and when I practice, clients want lawyers who will fight for them. And I think lawyers should fight for them. But there's a way to fight. So being aggressive, as you can see, that doesn't mean being disruptive or discourteous. So to me, yes, we should be zealous advocates, but it's not should we, it's how should we be zealous advocates. And in the legal profession is one of the few professions where we are in competition with another professional to try to defeat them. Okay, this is a rare thing in the profession. So my brother's a doctor, and I'm not aware of any doctors performing a surgery and some other doctor trying to hit away the scalpel when they're trying to perform that surgery. Okay, so one of the few professions that does have this is sports. So Mike Singletary played for the Chicago Bears, NFL Hall of Famer. He was a hard hitter who played ferociously. That was his reputation. Bill Romanowski, he was also an NFL linebacker, and as you can see here, he spit on, punched, and kicked opposing players. He actually ended his own teammate's career by breaking his teammate's eye socket in practice. Okay, so that was his reputation. So some lawyers are like Singletary, they fight hard but fairly. Others, too many, are like Romanowski. They just play dirty. Okay, they play dirty. And in the preamble to the Texas Rules of Professional Conduct, it says we need to zealously pursue our client's interests within the bounds of the law. And in the ABA preamble, the model rules, it talks about being a zealous advocate while maintaining civility, okay? And I'm sure all the folks in here are examples of that. So let's look at this zealous advocacy argument with some of the proposed rules. One of them is avoiding one of the proposed civility rules I have in there, which is very similar actually to the Michigan rule. And that particular rule I'm taking, it was from the Dondi case. And in the rule, I've shortened it here. It's in its entirety later, but it's avoid disparaging personal remarks. Okay, so my mom was born and raised in Poland, as you could probably tell, and my dad was born and raised in Guyana in South America, which is why I say I have these weird-looking eyebrows. To be a good opposing counsel, zealous advocacy wouldn't be saying, hey, David, your eyebrows are weird, they're thick, they're strange. That has nothing to do with zealous advocacy. Attacking someone personally, that's not zealous advocacy. So the rule wouldn't prohibit questioning the credibility of a witness on the stand. What it would prohibit is personal attacks, ad hominem attacks on another individual involved in the case, with the court, personnel, opposing party, opposing counsel, whomever. This is another one of the proposed rules. Commit oral understandings to writing accurately and completely. Provide other counsel with a copy for review. Never include matters on which there has been no agreement without explicitly advising other counsel. So you and I reach an agreement on something, whether it's dates, whether it's something substantive relating to the case, and we write it down. Okay? Now, if I want to argue about, no, I didn't agree with that, no, we also agreed to all these other things, that's not zealous advocacy. That's just me being discourteous, being maybe dishonest as well, if we didn't actually agree on those other things, and just being obstreperous. Okay, that has nothing to do with zealous advocacy. So here's another myth. The civility rules are too vague and difficult to enforce. What is civility? What is civility? It's too vague. I don't know what that means. I'm not sure. Well, courts previously used the age of reason, which was 7. So if anybody's had kids, they know that your kids know what right from wrong, even younger than 7 years old, okay, a lot younger. We all know what's right. We all know what's wrong. And pretending that, I called that person an idiot, I had no clue that was uncivil. Here's an actual, this is from an actual case in South Carolina. And this is when the civility oath had just become mandatory, and a lawyer was challenging the constitutionality of that civility rule and its enforcement. So here is the email in a case sent from one lawyer to the other. I have a client who is a drug dealer on Fifth Street downtown. He informed me that your daughter, the daughter of the lawyer had nothing to do with the case, was detained for buying cocaine and heroin. She is or was a teenager, right? This happened at night in a known high-crime drug area where also many shootings take place. Lucky for her and the 2 other teens, they weren't charged. Does this make you and your wife bad parents? Okay, this is an email sent from one lawyer to the other. It continued. This incident is far worse than the allegations your client is making. I just thought it was ironic. You claim this case so serious and complicated. There's nothing more complicated and serious than having a child grow up in a high-class white family with parents who are highly educated and financially successful, and their child turning out buying drugs from a crackhead at night on or near Fifth Street. Think about it. Am I right? So the other parent of the lawyer who got this email was also a lawyer. So she filed a complaint with the State Bar of South Carolina. The lawyer who sent this email, what was his defense? Zealous advocacy. I brought in the poor child rearing abilities of my opposing counsel because that was zealous advocacy. And I pointed out what happened to their child, zealous advocacy. And then he said, wait a second, I don't even know what civility is. Was this uncivil? Was it not uncivil? Who knows? I wasn't on notice. It was a due process argument. I wasn't on notice of whether this was civil or uncivil. And the court said, there may be instances where we're not sure how uncivil or uncivil this is or is not, but this is not one of them. This went way beyond the pale. This was absolutely out of bounds, inappropriate. The daughter had nothing to do with the case, and now you're bringing in this person's family, so that failed. And then the lawyer said, hey, you're going to chill my free speech. I should be able to say whatever I want when I'm representing my client. That's what it means to be a lawyer. Well, lawyers have limited free speech. It's not unlimited free speech. So hopefully all of us, and they upheld the oath and the ability of the State Bar to enforce civility through this case. The sanction for this case, sending this email, remember, Don't send the email. You may want to write the email, write it, get your emotions out. Don't send it. He sent the email. The sanctions for this case, a private reprimand. So if you look up this case, it's called In Re Anonymous. Okay, so even with this nasty email, the sanction was only a private reprimand. The only reason, one of the reasons they published it was to try to say, look, we don't want this happening out there anymore. So here's some more parts of the rules are too vague. So the proposed rules that I have try to reduce the discretion in terms of adjudicating a violation. So one of them is one of my proposed rules, lawyers shall identify clearly for other counsel or parties all changes that they have made in documents submitted to them for review. Transactional lawyers, they love this proposed rule because now it's something that specifically applies to them. You tell us if you make changes to what we're negotiating the contract, just make it clear. Put it in track changes. Make a clear note that there's some type of change. And also, when I practice law as a litigator, you're writing settlement agreements. So this is also very helpful for that as well. But it's hard to figure out, well, what does that mean? This is not a vague rule. It's easy. It's a straightforward rule. We can identify, did they identify the changes that they made clearly to the other side? Okay, this is not something that would be hard to enforce. Myth number 5, civility rules attack racial minorities and women while favoring the elite. So this is one that is gaining a lot of traction in terms of just civility in general. Just civility in general. And another quote that's not up there, civility codes lack neutrality and carry the imprint of a class contingent image of civility and courtesy. Those are the arguments that, wait a sec, you're trying to, and this is where the word civility came from, it's true, civilize, let's make these inferior folks, let's bring them up to speed. Okay, that's the argument that is out there, and it is gaining traction. But first of all, let's look at this. The proposed mandatory civility rules, you've already seen a few. Don't attack someone personally with disparaging remarks. Let's write our agreements down accurately. Let's make sure that we identify changes we made in a document. That's something that everybody, regardless of race, religion, creed, any of those things, should be doing as lawyers anyway. It applies to everybody. But also, let's look at that first rule, forbids specifically disparaging personal remarks based on race, gender, or other protected personal characteristics. Civility rules, this one for sure would actually benefit, not constrain racial minorities and women. And I do cite, a lot of times people will say, and studies show, but in the article, there are a number of studies that show in the legal profession and in other professions, typically, usually, the targets of incivility are racial minorities and women. They're the targets of incivility. So having rules punishing, potentially sanctioning incivility would protect those individuals. Okay, it wouldn't constrain them, it would protect them. Right, so here are some existing mandatory civility rules. So I showed you the South Carolina oath, and here's the rule for Michigan, which they've included. It's part of their rules of professional conduct. Lawyers shall treat with courtesy and respect all persons involved in the legal process. Lawyers shall take particular care to avoid treating such a person discourteously or disrespectfully because of their race, gender, or other protected personal characteristic. To the extent possible, lawyers shall require subordinate lawyers and non-lawyer assistants to provide such courteous and respectful treatment. All right, we talked about California potentially making civility mandatory. Well, here's the rule. Here's the new proposed rule. And they're also going to make it part of their rules of professional conduct. In representing a client, a lawyer shall not engage in incivility in the practice of law-related professional activities. For purposes of this rule, incivility means significantly unprofessional conduct that is abusive or harassing and shall be determined on the basis of all the facts and circumstances surrounding the conduct. Okay, so it's still general. It's still general. And here are my proposed rules. And this first one is coming from Dondi, citing the American College of Trial Lawyers Code of Trial Conduct. Okay, so this is about disparaging. You cannot make disparaging remarks towards any individual who's involved in the legal process. And all these civility rules are in relation to the practice of law. It's not in someone's personal capacity, but it would include when you're practicing, when you were at some bar event, a annual meeting, let's say. Another thing that's added in this is insults about a lawyer's work or work product are also unacceptable. So last year, there was a brief filed in the Supreme Court of the United States, and in the brief, it referred to opposing counsel's brief as hot garbage. So, I mean, we have a room full of judges in here, and I'm wondering, show of hands, when you see that description, hot garbage, can you tell what's wrong with opposing counsel's brief? Hands are flying up. Of course not, right? It's not. And then what does it look like? Then the ABA gets a hold of it. It's a story. It's a news story. And now our legal profession looks like the Real Housewives of whatever city they're in right now. I think they're in every city at this point. Real Housewives of Minneapolis is where I'm at now. So it doesn't look good. Now, that doesn't mean you can't criticize the opposing counsel's brief. It's deficient for these 5 reasons. In one of the elements, they're missing evidence. It omits this important precedent. You can do that. But just name calling, what does that do? That doesn't help anybody figure out the issues or figure out the true deficiencies, if there are any, in opposing counsel's brief. Here's the second one. This is actually from the Dallas Bar Association Guidelines of Professional Courtesy. So this is, I'm going to try to communicate and figure out when we have some type of, can we schedule these things? Are there conflicts? If there is something that comes up, I'm going to tell you as soon as possible. This was the only time, by the way, when, in relation to this rule, when I was uncivil, when I practiced. When I was trying to get a deposition date, the other side wouldn't even respond to me. They wouldn't even return my phone calls, wouldn't return my emails. So I had to bring a motion to compel just to get a deposition date. So this is when I lived in Texas. I was licensed, still am, in Texas and California. And a lot of my cases, some of my cases were in California. So I had to go out to California to get that date for the deposition. So we finally get the deposition date. I'm flying out there. I just had my wife just had our second son. And so I'm flying out there. My kids are 2 years and a newborn. And I'm flying out there to lovely Fresno, California, eating at a very fine establishment, Denny's. And I get a text on my BlackBerry. So this was from 1804. And opposing counsel said, the lawyer who was going to defend the deposition is sick. Deposition's postponed. This is the one that I had to file a motion to postpone. Well, I started yelling, and I don't swear. So there was a lot of dadgum and darn it and doohickey that I was yelling at him. And I knew this. I knew opposing counsel well. I knew he had kids, and I have kids. I have kids, and I flew out here, and I'm yelling at him, going crazy. And afterwards, the next day, I called, and I said, look, I apologize. That was unprofessional. I shouldn't have yelled at you. I shouldn't have said the things I said, and it was improper. And if we had civility rules and someone called me and said, David, that was completely inappropriate, I would have said, yeah, absolutely, right? But that also would have been in one of the parts where it was an isolated incident, where it wouldn't have risen to any type of violation of a civility rule. But this is the one that reminds me of that, because that's what happened. If we can just work together, and again, not to prejudice the client, we're not going to have a deposition date 3 years from now because you're busy until then. That's not going to happen. But I am going to try to work with you so that we can figure out dates and times that work. All right, so here are 3 more. These are the last 3. The first one is from the Dallas Bar Association Guidelines of Professional Courtesy. The second one is from the Arizona Rules Supreme Court, one of those rules relating to it. And the fifth one is from the American Board of Trial Advocates. Grant reasonable extensions of time to counsel where such extensions will not have a material adverse effect on the rights of the client. I gave a talk on civility in San Antonio. One of the lawyers told this story. I will never forget it, and certainly the folks who heard it will never forget. Opposing counsel said to this lawyer, hey, can I get an extension on the trial? Can we move the trial back a month? My wife's really sick. Lawyer, the person I was presenting, yeah, that's fine. We'll move it back. Talk to the client. Not going to prejudice the client. A month later, the opposing counsel again comes back. Hey, can I get an extension? Can we move the trial, get a continuance? My wife is really sick. And the lawyer says, oh, yeah, no problem. That's fine. We'll give you another month. So the next time, the third month, the lawyer says, hey, can I have another month here? My wife's really sick. And then by this time, the lawyer's like, I think this guy is, he's doing, this is a game. He's trying to play me. He's trying to get some advantage. I don't know what's happening. So he said, no, I'm not going to give you that extension. So they show up for the first day of the trial in the morning. Opposing counsel says to the judge, Judge, can we start this trial in the afternoon? I'd like to attend my wife's funeral. So when we think about as lawyers, should I give that? I always gave the extension. I checked with my client, Chevron, who I was representing a lot. Can we give that extension? Yes. Is it going to hurt us, David? Is this going to hurt us materially in the case? No, it's not. Let's do it. Because sometimes it was opposing counsel's child was sick, or the witness or their client wasn't able to finish the interrogatories or help them finish the interrogatories, answering the questions, whatever the case may be. So not only should we be granting those extensions and those continuances, or at least not opposing those continuances because it's the right thing to do, and that's how we'd want to be treated as well. If something came up with us, we would hope that the opposing counsel would say, yeah, I'll give you an extension. Every time I asked for an extension, which was rare, it was always granted by the other side because I'd shown them that same courtesy. So number 4, we talked about it already, identifying changes made to document, and also we talked about number 5 as well. So here are some arguments against mandatory civility, and this is one of the big ones, strategic incivility. No. I'm not going to be civil. My whole tactic is to be uncivil. I want to be a jerk. I'm going to get them off their feet. I'm gonna distract them. This is going to take them away from the merits of the case. Just because you can do something doesn't mean that you should. Okay, and even if a lawyer is being uncivil, and let's say they are somehow winning, then there are still those significant costs to the client, to the courts, to the public perception of lawyers. If I'm being obstreperous and fighting opposing counsel on every single thing, and then we finally get to the end of the case and we're supposed to negotiate a settlement, how easy is that going to go? Is it going to be harder because I've been a jerk the whole way through? And here's a big one, especially when I taught in Texas for 9 years. And it was fun teaching in Texas when people found out that I played football at Rice, because they'd look me up and down for a few minutes and say, where's the rest of you? Anyway. But lawyers prevail in spite. If they prevail in spite of incivility, not because of it. And in Texas, I got a number of students saying, I knew, or my parents or my uncle or aunt knew Joe Jamel, the late Joe Jamel. And he was, you can find some deposition, Texas-style deposition. It's out there on the internet. And if anybody here knew Joe Jamel, the accounts of Joe Jamel are pretty consistent. He was brilliant. He was always well prepared. He always created an incredible rapport with juries, and he was fearless. So if people argue, well, he was winning because he was uncivil, I would argue he was winning because of all those other things that made him a great lawyer. And all those other things, being well prepared, being fearless, creating that great rapport with the juries, and of course being brilliant, you can be all those things and civil as well. So sometimes folks, and that's always the person that they say, Joe Jamel, and trust me, I understand Joe Jamel. We played at the Joe Jamel Stadium at UT in Austin, and the week before we played Ricky Williams his senior year, Kansas State had held him to, I think, 64 yards. So we had his number when he was going to come to Rice. When we were going to play him, we actually were playing at Texas, and we held Ricky Williams, I think, to 365 yards, and I think 6 touchdowns. I think on the Heisman Trophy he said, "Thank you, Rice." So many lawyers actually credit civility as necessary for effective advocacy. There is something called professional identity formation, which is looking at what are the characteristics and traits and values that go into being a great lawyer. It's not just thinking like a lawyer, it's also acting like a lawyer. And there are scholars who argue that civility is one of the benchmarks, one of the cornerstones of being an effective lawyer. And you have here, this says both judges and juries are known to respect a lawyer who refrains from responding to or engaging in incivility. We have an individual in here, Jonathan Schmaby, who wrote an article about this, and he's in here right now, and that talked about decision makers. Yeah, you're waving the white. Oh, there he is. I thought you were waving the white flag, but that was not Jonathan, but Jonathan's right there. So that decision makers, they value professionalism. They value civility in making their decisions as a juries or as a judge. So civility is a strategic decision to help your client. So here, and literally, I've talked about civility and mandatory civility in local state bars, and nationally several times. And this is the number one reason that people argue there is not civility in the legal field. It's judges. I don't agree with that. I do not agree with that. But this is the argument, that judges are the answers. Judges can stop this. Judges need to act more civil. Judges need to condemn incivility. Then we'd have more civility in the legal profession. I don't agree, but that's the argument. And the reality in Texas with state court judges, how am I going to punish somebody when, one, I don't know exactly for sure 100% who did what if this is happening outside of my courtroom, and how am I going to do good as a judge if I'm not reelected? That's a real concern. Okay, in the states that have where the judges are reelected, that's a real concern. And like I said, sometimes incivility occurs outside of the courtroom. The other thing is that if we have transactional matters, judges have nothing to do with that. Okay, it's only things in their court that they have the inherent power to deal with. And then if courts do become the sole arbiters of civility issues, then they would turn into hall monitors. And now that's all we're doing in court is motions to compel and motions to this, that, and the other. Okay, under mandatory civility rules, if it didn't happen in front of the judge can refer it to the state bar, let them handle it. Okay. And judge, this is another one. Judgment calls will be necessary. Judgment calls are already necessary, right? They're the people who handle the issues, the alleged violations of the rules of professional conduct. They have to make judgment calls all the time. That's part of what they are doing, and we have to make sure that you have to have trust in the folks who are doing that job. So here's another argument. Well, the ethics rules already cover it. They don't. And talking to one of the disciplinary counsel, she says, Merritt Vasella, a lot of times people try to use the existing rules, whether they're civil procedure rules, the rules of professional conduct, or even local rules. Sometimes they don't get at that uncivil conduct, and it becomes unwieldy to try to apply those rules to uncivil behavior. The ethics rules I just talked about are not covered. The ethics rules are not covering the proposed civility rules that I just talked. Those are the concussions talking here. Sorry about that. Whenever I make a mistake, I blame the concussions. But I had 3 concussions, but they haven't affected me a bit. All right. Okay. All right. Yeah. My wife and kids have to live with the. Now you understand the nickname they gave me. All right. That's a callback joke. All right. So here's another one. Rule point 84G already covers uncivil conduct. It prohibits, the ABA model rule prohibits discrimination and harassment based on those characteristics, but it's limited to remarks that manifest bias or prejudice, where my proposed civility rule is not limited to that. It also uncovers attorney work product as well, and it's not limited to manifesting bias or prejudice. And most states haven't even adopted Rule 8.4G. There have been 2 states, Vermont, New Mexico, that adopted it in its entirety, but most states haven't even adopted it, so it wouldn't help most states anyway. So concern regarding abuse of civility rules, again, this is already a possibility. Someone can already use the ethics rules, the rules of procedure, to say the other side is delaying, is harassing. That already happens. You have to trust the people who are running the system, who are making decisions, adjudicating, investigating, adjudicating these types of things. So well done is better than well said. Tom Brady's father said that. Tom Brady said that, and some feller named Benjamin Franklin said it as well. So at some point, I hope that Texas gets to the point where it says, we want to be a model for other states. We want to show how you can advocate aggressively, zealously, fight for our clients while maintaining civility. And if someone steps beyond those bounds, there is a potential that they may be sanctioned. And at some point, it can't be talking about it. I hope you're civil. I hope you're nice. We demand it from our lawyers. It's a higher standard. And looking at the rules, it's not that great a standard. That's the sad part. It's not acting like, this is not, you have to become the next Abraham Lincoln. It's not that. These are basic, fundamental things that all lawyers should do in the practice of law to show that courtesy, to show that dignity, to show that respect, to show that restraint in order to practice law. Thank you all so much for having me. I really appreciated the opportunity to speak to you. Thank you to Justice Lang for initiating all of this, for having me. It was a great time. I really appreciate it. Thank you.
Good.
Yeah, sorry, the last slide was questions, apologies. I've been married for 20 years, so I usually start with an apology. But if anybody has questions, I'll be happy to talk afterwards. Thank you.
Thank you so much, Professor Granardo. We are so fortunate to have you share with us this morning. And now we are going to have some remarks from Chief Justice Hecht.
Thank you, David. You provoked me to tell my story about when I first met Joe Jamel. We were going to be on a CLE panel together, and we were standing in line to go up on the stage, and he was in front of me. He turned around and said to me, I'd never met him before. He said, I'm going to kick your tail. Except he didn't say tail. And I didn't know what to think. And we went out on the stage, and we got through a little while later, and we coming back off the stage, and he turned around and said to me, you know, you're not as big a jerk as everybody says you are. And he didn't use the word jerk. And I said, well, you are. And then I've always said since we were both right. But he was a good friend, and I think David captured a lot of who he was in his comments. Just a word on the state of the judiciary. Thanks to the bar for having this bench bar breakfast this morning. I'll just say a couple of things. Our priority has to continue to be a just compensation for the judges. It's been we've not had an increase in the base salary since 2013. I tell people that when I started on the bench 43 years ago as a district judge in Dallas here, I made $1,000 less than a United States district judge. And now, of course, the disparity between the base salary for state district judges and the salary for United States district judges is quite wide. So we continue to work on that. And I just want to assure the judges here this morning that this continues to be a top priority to persuade the legislature to increase the base salary of judges. We did get a 10-year raise a couple of sessions ago, but we're interested in getting the base salary increased. I'll tell you one thing that I think is helping that, and that is the creation of the business courts. So one thing that can happen with compensation it's been my experience over the years, is that it gets to be kind of an expectation. I know some of my legislator friends say, oh, the judges are always coming over here for a raise. That's all you ever talk about. And so it kind of gets to be part of a drill, a routine, if you will. And I think with the creation of new courts in our state and the introduction of new judges, that gives us an opportunity to say, look, this is really out of kilter now. Let's take another look at this. And I think it will help. You've already heard that the business courts have been staffed by the governor. We have 5 regions, Dallas here, Fort Worth, Austin, San Antonio, and Houston. We have 10 judges that will be in service coming September the 1st, and 6 of them have no prior judicial experience. So it will be an opportunity for us to see a development of a special court in our system, but also to call attention to the work that the judiciary is doing otherwise. So I'm hopeful that this will give us a good opportunity to advance the cause of the judiciary, both as we're working together and also with the legislature. Just a couple of other things. Filings are down. You may know that. Criminal cases in the district courts are down 40% since before the pandemic, so that's quite a bit. The civil and family and juvenile filings have been pretty steady. In the county courts, the criminal cases are also declining there. And again, as with the district courts, the civil, family, and juvenile filings are all about the same. The backlog is mostly gone. There's still some in the criminal system, and we're working on it. Our latest figures are that the clearance rate in the district courts in criminal cases is 104%. So that means we're disposing of more cases than we're having filed. We're catching up. And the same thing is happening in the county courts. The clearance rate is 107%. So that's good news. The civil clearance rate is down a little bit in the district courts and the county courts, but we think that's because everybody's working on criminal cases, which is good because they kind of stacked up on us a little bit during the pandemic because it was very difficult to impanel juries to try those cases. But the general prognosis is that we're in a better place and advancing, and we can be proud of that. We've been talking some while we've been here about when the pandemic hit and how it affected us. I remember it was the Monday after Friday the 13th, March 13, 2020, that we were trying to figure out what's the world going to look like. The chief judge in New York called and said, what are y'all going to do about keeping the courts operational? And I was the president of the Chiefs at the time, and the New York did not have e-filing, still does not have e-filing in a lot of cases, most of the state. So I said, well, we've got e-filing, and people are going to push a button, and documents are going to go to the court, and we're going to try to keep operating. But it was that kind of thing all over the country, and now we're on the backside of that. I had no idea what Zoom was in March 2020. Now a week doesn't go by that I don't have 5 Zoom meetings, and it has changed a lot of the operation that we have in the judiciary and, of course, in the practice as well. One big change that is coming, there will be more data generated regarding the operations of the courts. So the third branch across the United States has historically been kind of beyond data. We don't collect a lot of statistics. I think as judges, historically, we have thought that statistics can be very misleading because they certainly can be. You can look at some disposition rates and they seem high as the sky, and then you look at what the cases were and they're not that complicated. Then you look at another docket and the judge is disposing of 2 cases a month, but they're 3-week trials or long trials and lots of motions. And so we don't want to run into that problem, but we do need to know internally what our dockets are looking like so that we can plan operationally to be able to meet them. But we also want to tell a better story to the other 2 branches and also to the public about the very important work that's being done in the justice system so that people will have confidence and say, thank goodness that this is happening. It's especially important that we do this in a time that we all recognize where hardly a day goes by that there's not a criticism of some court on the front page of the paper for this or that decision. And when the public outside the justice system, when that's all they see, then we need a better rebuttal than that. We need to tell all of the important things that are being done and have a more positive presentation of that. So there'll be efforts. I know the legislature is interested in this. They've already taken steps. We'll be taking steps internally in the judiciary to generate more data about our operations, and I hope to use that positively in our presentation to the public. In fact, I'm very grateful for the award earlier. Access to justice continues to be very important. It's important to the judiciary in our state. It's important to the state bar. The State Bar of Texas lawyers provide millions of hours of pro bono representation every year. We've taken polls on this. We've done studies. It is a very strong contribution to access to justice, just coming from the organized bar, coming from practitioners across the state. But there's also strong support for legal aid providers. I know every year the Dallas Bar Head Notes tells of all the contributions that members of the bar here have made. It's happening in Houston and Austin and around the state, and that's a strong contribution as well. But the problem is gigantic, and we must, as members of the legal profession and the bench, we can't ever let up in trying to call attention to the need that is there. We have had very good support from our legislature, and they regard it generally as a good government issue. I have not perceived it to be partisan in a long time, and that's there's a short list of those subjects these days, and that's really good for us, and it's good for the way that we have preached access to justice as strongly as we have. I'm coming to the end of my 43rd year on the bench, and I continue to be helping the National Center for State Courts in courts across the country. So I can say this not just because everything's better in Texas, but I can say it with some authority that we have a very strong court system in Texas that we can be very proud of. It's been a great blessing for me to be a part of it for a long time, and we look forward to strong things ahead. Thanks very much.
Thank you very much for those remarks, Chief Justice Heck. We are all very grateful for your esteemed service to the bar and all of your insights and all of the work that you continue to do on behalf of the judiciary for the citizens of Texas. Thank you all for attending this morning's program. Again, we have a full day of CLE ahead. I look forward to joining you all for the general session here for the noon lunch hour, where Steve Benish will be sworn in as the 144th president of the State Bar of Texas, and Judge Irma Ramirez will give our keynote address. So I will see you all back here at noon. Please enjoy this morning's CLE lineup and have fun. Thank you.